And then we're going to start in 3, 2, 1. We're live. Looks like we're good to start, Jesse.
Okay. All right. Good afternoon, everybody. Thank you for joining us today. I want to introduce myself. My name is Jesse DePauw. I am the co-chair of the appellate practice section of the MDTC. And I wanted to thank you for joining us for this webinar this morning, or this afternoon now. We are going to be discussing in this webinar some of the Supreme Court opinions that came out this past term, the 2022-2023 term. We titled this webinar an uphill battle, and it might have been a little hyperbolic, but I think the theme of some of these cases are that they're not particularly defense friendly, and they're undoing some longstanding precedent that we as a defense have relied upon for the last, I don't know, in some cases 20 years in obtaining summary dispositions and resolving cases. So our goal today is to discuss and explain 10 cases that came out just this term, and then take some questions and explain how they affect our cases moving forward, how they are likely to impact our practical defense of these cases in these specific avenues, and go from there. So I wanted to make sure to explain that we're welcoming your guys' questions. There is a Q&A function as well as a chat function. You can put your questions in there. If it's to a specific case that we're explaining at the time, we'll try to get to it before we move on to another case. But we are hoping to reserve some time at the end to take questions from all the cases. So if you don't think of it in time, that's fine. Go ahead and throw it in the chat, and then we'll hopefully get to them at the end. So I also wanted to, let's get this thing working. I also wanted to note that we have, the MDTC has some events coming up that we want to encourage our members to attend, sign up for. The first is the winter meeting. It's November 3rd at the Sheraton Detroit Novi Hotel. I know I went last year. I plan to go this year. Always a great event. The summer and winter meetings are when I learn the most and get to meet the most people. So please, if you're interested, sign up and attend. And also we have the Legal Excellence Awards coming up next year. I can't believe it's already coming up. It's March 21st at the Gem Theater. That is a huge event. Always has really good attendance. So if you want to meet more people, get more involved in the MDTC, please sign up and join us. Okay, so without further ado, I wanted to introduce our first presenter. That's Drew Broaddus. He is a partner at Seacrest Worrell. He specializes in appellate and insurance coverage practice groups, and he's also a member of the amicus committee for the MTTC, where they help decide what amicus briefs we're going to file in the Court of Appeals in the Supreme Court. So, Drew, go ahead and take it away for our first case.
Thanks a lot. So here's the slides. All right. So need to get my camera in focus here. So we're talking today about premises liability and specifically the recent changes to the open and obvious doctrine. And if you're on this call, you probably know a thing or two about this already. My goal is to maybe give some new insight on this case that's relatively new, but kind of feels like it's been around for a while. So we've been talking about it for well over a year with the two MOA orders that kind of prefigured what the court was going to do here. Next slide, please. So premises, this has its origins. It kind of bled over into premises in the early 60s, this idea of open and obvious. It had been a products liability concept for a while. And so what we got, it came over in the context, though, typically of a jury question. And those back then, the difference between jury, summary disposition, this is in the era where before summary disposition practice had really taken off. And I call this the olden days, kind of before 1985, which was the key year that the Michigan court rules were amended. And also that, some of the federal case law that the Michigan court rules are based on really sort of gave motion practice kind of a new life. So Lugo is the first case to really say in 2001, after this kind of bounced around for a number of years, sometimes being a jury question, sometimes being a motion issue. Lugo in 2001 expressly says this is a component of duty rather than breach. And if you see on the slide there, that's attributed at least to Justice Weaver's dissent in Lugo. She also noted in that dissent that the special aspects doctrine was new to Michigan jurisprudence at that time. Next slide, please. Can we get the next slide, please? Thank you. Sorry. So the key holding of Lugo is summarized on this slide. It's really, as we all know, property owner had no duty to protect against to protect an invitee, and that's important too. And we'll talk about that later. From an unreasonable risk of harm caused by a dangerous condition on the land. Open and obvious dangers are one which an average person of ordinary intelligence. I won't read the slide. You'll get the gist of it. You've been doing this for years, likely. Next slide, please. So again, up to Lugo, this idea of open and obvious had bounced around for a long time, but this is really where it becomes a motion issue in a huge swath of cases. And this is the key change that we're dealing with now is the default rule when we get a premises case is no longer how do we position it for a dispositive motion on open and obvious. It's got to be worked up in other ways, although that's still something that we should be thinking about in particular cases, and we'll get back to that. Next slide, please. So the cracks start to emerge, and I guess we're trying to get be cute here with cracks that we would trip on, premises liability. So cracks emerge, in the Livings case, 2021, just 2 years ago, where the majority deals with special aspects. And really the issue here is that special aspects, the take that the majority took here kind of expanded that significantly from what it had meant before. Basically, this was a waitress that needed to get into a diner to start her shift. Parking lot was completely frozen over. She argued that although it was obviously frozen over, it was unavoidable because she needed to get to work. And the majority here agreed with this and said it was a special aspect. This overruled a 2014 published Court of Appeals opinion that reached a different result about employment obligations. And what really kind of showed us that Lugo was on thin ice at this point was the concurring and dissenting opinions, including the opinion by Justice Clement, who ended up being in the majority on Kandil-Elsayed, which might have surprised some. So the handwriting's kind of on the wall there. Next slide, please. So then we get the MOA order in Kandil-Elsayed, February 2022, which kind of who everyone, I think, at least in my circle, started talking about this. This was really an unremarkable, unpublished Court of Appeals opinion, in my view. The plaintiff slipped and fell on a snow-covered walkway in front of a gas station. Trial court dismissed on open and obvious, no special aspects. Court of Appeals affirms 3-0. But this is one of the cases that gets the court's attention for whatever reason. They issue the MOA order, request supplemental briefs on whether Lugo can be reconciled with comparative negligence. And if so, what rule should replace it? Next slide, please. And this is, Pinsky. There were actually two other companion cases in front of the Supreme Court that got similar orders that settled before the decision last July. But Pinsky did go up to the Supreme Court all the way, and this was a very similar in the sense that it's another pretty unremarkable, unpublished Court of Appeals opinion that the Supreme Court grabbed onto and said, we're going to use this as the vehicle to take a look at Lugo. Next slide, please. So the holding of Kandil-Elsayed and Pinsky found that Lugo incorrectly answered the questions that were posed in the two MOA orders. Lugo's holding was not reconcilable with comparative fault. So the majority explained that this duty exists. Open and obvious is not a component of duty to the extent Lugo said that it was overruled. So the open and obvious nature of a condition, whether it be ice or anything else, really, it remains relevant, but it's part of the breach of duty inquiry and possibly comparative fault. So what that means, next slide, please. As a practical matter, what that means for us is going to be a jury question most of the time. This was based on the restatements, and there's some deep dive in this opinion into some common law principles and the various permutations of the restatement. But at the end of the day, the takeaway here is by shifting this from duty to breach, it's going to be a motion argument in a lot fewer cases. It's still an issue, still defense, but not one that's going to take care of the case after minimal discovery. Next slide, please. And but related to this, there's an interesting footnote too in the opinion. The court talked about the fact that although the default rule is that duty is for the judge and breach is for the jury, that's not always the case in every situation, and there can be particular cases where the evidence concerning the lack of a breach is such that you can still move for summary on that issue. So open and obvious motions may still exist. It's going to be important that they're framed in such a way that you're arguing the lack of a breach of duty rather than the lack of a duty owed in the first instance. And clearly, reading this opinion, that's not going to be a common scenario, but one that shouldn't be overlooked. Next slide, please. I suppose the other area where motions could still exist is when we're dealing with non-invitees. The court made it clear that they were not altering the traditional status-based categories, licensee, invitee, trespasser. They mentioned that in such a way that it may still be up for grabs down the road, but in this opinion, this time, those categories still exist. And there's this published opinion from the Court of Appeals from 2001. Pippin's talked about on this slide. And you read that, there seems to be at least a passable argument that open and obvious still exists for licensees. It might be a stretch. Haven't fleshed that out yet, but it's interesting. Shouldn't be overlooked because of the lesser duty that licensees are owed. Next slide, please. So then we talk about, retroactivity and some of the other cases we've seen in the last few years. This has been an issue. I don't think it's going to be an issue here. The general rule is it's going to have retroactive effect. And what we've seen so far, next slide, please, is the Court of Appeals the Supreme Court is kind of signaling this with the number of cases that it held in abeyance pending this decision, and which logically would make sense for them to hold on to a bunch of cases. And then when it comes down, say, oh, it doesn't apply to these cases. So I think tacitly, if not expressly, that's been decided. I've already had a couple cases sent back from the Supreme Court to the Court of Appeals because of this. So again, reading between the lines, retroactivity is kind of off the table. there's also been a few Court of Appeals opinions, seems to be pretty much automatically just sending these back to the trial court. So that's where we stand. And then the final slide is just my take on this. The court is the ice, and Lugo is falling on the ice of the Michigan Supreme Court, and special aspects are gone, and that's the person's coffee there, just they're off the table. So thank you. And again, any questions, feel free.
Okay, I don't see anything in the chat currently, but again, if any of the attendees think of any questions or comments they want to discuss on this case, we'll hopefully have some time at the end. But until that time, I wanted to go ahead and introduce our next presenter. That is Grant Jaskulski. He is my co-chair for the appellate practice section here at the MDTC. He is a partner at Hewson and Van Helmont. He is a member of the amicus committee as well here at the MDTC, and he's done a lot of help getting, me and him have been working on getting this presentation together. So please welcome Grant.
Yeah, good morning. So I'm going to just be talking about two no-fault cases, the two big no-fault cases from the Supreme Court. I don't have a lot of slides here, just the title, so you're just going to have to bear with me on looking at my face and listening to what I have to say about them. But first up, there's the Wilmore-Moody versus Zakir case, and then this is a bit of an outlier in our decisions that we've seen this term, just because it's actually unanimous. And it was relatively short. We've seen a lot of lengthy opinions here. This one I think is only 11 pages long. But so this case basically it concerns how rescission would affect a claim for third-party damages under the No Fault Act. And those are different than our more traditional PIP damages or PIP claims that you go against the insurer. These are third-party claims against the at-fault driver or the other person involved in the accident, which is pretty important coming up later on when the holding comes out, really, and how it might impact some other cases. So these are those serious impairment cases with non-economic damages like pain and suffering and things like that. So in this case, the plaintiff was rear-ended by the defendant. She had insurance, PIP insurance through Everest, but when she tried to claim those PIP benefits, Everest rescinded her policy. They said in her application for benefits, she didn't disclose that her granddaughter lived with her. They refunded her premiums. The policy was considered void ab initio, as if it never existed in the first place, which is all really relatively straightforward under Titan versus Heighton and under Bozzi. And really for purposes of this decision, there wasn't really any debate about the fact that her policy was rescinded. It's a valid rescission. She doesn't have any policy at the time of the accident, or so we thought. So she ends up bringing a tort claim against the guy who rear-ended her. And then he argued under Section 3135, subsection 2C, that barred her claim. And that section basically it governs all these third-party no-fault claims. And 2C specifically, I'll paraphrase it a bit, but it just basically says that a plaintiff can't recover any third-party damages if she's operating her own uninsured vehicle at the time of the accident. The defendant was saying, look, the policy's been rescinded. Her vehicle is now considered uninsured at the time of the accident, so she can't sue me. And when it went up to the Supreme Court, they did not agree, because they basically said this rescission only applies to the contracting parties. It only affects the insured and the insurance company. So since this defendant was obviously not a party to that contract, and he wasn't defrauded by her misrepresentations in her application, he really couldn't use the fact that it was subsequently rescinded to use it as a defense. And the court also basically said the fact that Everest chose to rescind it won't impact him. And then the court goes into this big discussion about rescission being a, quote, legal fiction, and holding literally that it does not alter reality or act as a DeLorean time machine, which was actually in the Supreme Court's opinion. And this is where the court, I feel, really goes into a bit of the unknown. There's not much case law outside of, I think, a single dissent from the Supreme Court in Michigan, and then a few Court of Appeals cases that kind of led up to this, kind of like saying that rescission is a legal fiction. Even in other jurisdictions, this is not really how the case law has been. If anything, it had always been just the opposite. You know, courts treated the policy void ab initio as if it never existed. But now they're saying, well, for third-party defendants, we're going to treat the policy like it existed, like it was issued and in effect, and it's only going to apply. People that can only think that it's not a contract are the only people that can do that are the people that were parties to the contract. So he doesn't get to use this defense at all. He has to basically say, well, you lied in your application for benefits. The insurance company says you don't get any policy whatsoever, but for all intents and purposes, from my perspective, I have to act like you had a valid policy at the time of the accident and you did everything right. And that really flies in the face of how the case laws have been, in the past. And the reasoning of the decision is pretty interesting in my perspective, because it specifically says, you know, we're not going to talk about public policy. That's for the legislature to decide. And then it goes into a pretty lengthy discussion about public policy to say, well, you know, even if we were to consider public policy, this is how we would apply it here. And they basically, when you really look at it, it seems like they don't want to let a tortfeasor, somebody who actually did something wrong, to escape complete liability because somebody else defrauded somebody else. They don't want to it's almost like they don't want to let him out on a technicality. And in a way that does make sense, but then it's the question of how is their decision going to impact, you know, other situations? You know, I mentioned at the beginning that this is not a claim for PIP benefits. So how is this decision going to affect those claims for PIP benefits? And, you know, the Supreme Court explicitly didn't touch on those issues. It left them for another day, in its words. But the decision, and we saw this decision when it was at the Court of Appeals. There was another case, I think Bernard versus Avers, that had a similar holding. And they were both in third-party cases, and we were seeing them in first-party cases all the time. And I think this decision, although it has that public policy consideration, it's going to be kind of hard to say that how to differentiate it is kind of saying, well, the public policy is entirely different when it's an insurance company involved, because really the insurance company that might be on the hook for PIP benefits, whether it's, you know, a constructive ownership situation or whether it's a claim through the assigned claims plan, that insurance company wasn't a tortfeasor. They didn't do anything wrong to the injured party. But that's kind of the last paragraph of the Supreme Court's opinion, and they're saying that they're not deciding it based on public policy grounds. So it's kind of interesting on how are you going to differentiate it if the real differentiation is public policy grounds. And that's kind of where we're at with this one. I haven't seen it fully like being applied in a lot of cases, but I could see it just like we were seeing it before when it was just at the Court of Appeals. So that's basically Wilmore-Moody. Like I said, it was a pretty short opinion, so I tried to keep this part summary of it short. I'm not sure if anybody has any specific questions on this, but if not, we'll move on to the bigger opinion in the no fault realm, and that's the Andary decision. And this is not a short opinion. It was you know, over 50 pages with almost an equally long dissent that I don't think we really have time to get into here, but you know, I would encourage you to read it. It's actually like a pretty well-reasoned, or a very well-reasoned dissent, in my opinion. But so this decision is dealing with the 2019 no-fault reforms, and in particular, you know, the new fee schedule in Section 3157. So just a little bit of background, just very quickly, you know, PIP medical benefits used to be unlimited for the 50 years of the No Fault Act or so. You know, they were only really capped at what would be considered reasonable. But in 2019, all of that changed. You know, the legislature changed several aspects of the No Fault Act, and for better or for worse, which I don't really want to get into here. But among those reforms, they passed the fee schedule for PIP benefits, which has a lot of different requirements and caps and different things depending on the provider, whether there's a Medicare rate for the services, and different things like that. But this case is just dealing with the new limits on attendant care, which they do have some caps on the rates there, and they also have an hourly cap for friends and family. If you're related to the injured party, if you had a business relationship or a social relationship to the injured party before the accident, or if you live with the injured party, you can only provide 56 hours of attendant care. And even though they're only addressing that, I think their holding really doesn't specifically say it could easily be read to all of Section 3157, all of the new fee schedules. So even though it's pretty limited, it does have some pretty wide-reaching, potentially wide-reaching implications. So this case had two injured plaintiffs and a provider, which I'll get to later, and they were involved in accidents well before the 2019 reform. They were both covered under PIP policies, we think, because the court didn't even have one of those policies, but that really didn't matter to its decision. They just determined that these policies applied to them. They had contractual rights under the policies. They had a contractual right to benefits. So these people were really hurt in their accidents. They were receiving a lot of attendant care. And if the new fee schedule would apply to them, they'd end up being on the hook for a lot of their medical expenses because their insurers would only be paying 56 hours. And some of these, that's 8 hours a day. One of the plaintiffs in it was getting 36 hours of attendant care per day with multiple care providers. So they wanted to obviously keep their old unlimited benefits. And when it went up on the Supreme Court, they said they could. They said they had vested contractual rights to those benefits through those policies that applied to them. So basically the court said no fault benefits are both statutory and contractual, which has been kind of the holding or the way that we've understood it for a long time. But then it kind of talked about their specific contractual rights under the policy, and it explained that those rights vested at the time they were injured. And that's the real important part here, because that's kind of what drove the ensuing discussion about the retroactivity of these new amendments. So they basically, as I said, the statute, the benefits are both statutory and contractual. So there's a way that a statute could change a person's entitlement to benefits. So the court goes into a pretty long discussion, and I apologize for my cat, about whether this is going to be retroactive or prospective under LaFontaine. And even though there's so many factors in there, when you really go through what the court really held, it was all about the fact that these had vested contractual rights. So the new amendments wouldn't apply to them. And instead, it's going to be the version of the No Fault Act as it existed at the time of their injuries that will control their claims. Whether that's solely about Section 3157 or whether it's about the No Fault Act as a whole is another question. But that's the real important part, though, is that the contractual rights are really what was at issue. The court explicitly said that it wasn't going to decide purely statutory claims, whether those are claims under the assigned claims plan or potentially other claims involving, pre-amendment motorcyclists or uninsured passengers or pedestrians. It doesn't touch on those and explicitly doesn't touch on those. So that's still a question that's up for debate. I've seen that issue litigated in a bunch of cases already. We're trying to figure out what to do with Andary from that perspective. But generally, those are statutory rights. Those benefits would not be governed by any sort of vested contractual rights, and statutory rights by definition can never be vested. There's case law out there right now that says that, although with this, we don't know how the Supreme Court might interpret those in its new decisions. And there's also something that might actually impact that analysis, and that's there's a bill in the Senate right now that's trying to change the fee schedule entirely. And there it explicitly says that this is going to cover the fee schedule is only going to apply to accidents occurring after June 10th, 2019. And with that explicit holding or explicit demarcation in the law, that might actually impact whether this is now more explicitly saying these are the accidents that the new fee schedule applies to. Therefore, pre-amendment accidents, it definitely doesn't apply to, because it explicitly said it applies to one. So that might change how Andary is interpreted or applied in the future. But that, remains to be seen whether that's even going to become law. It was only introduced, I think, a week ago today. But that's just something to keep in mind. But there is a slight silver lining in this case. I mentioned before that there was also a medical provider that was involved in the case, raising a variety of constitutional issues, basically saying that the new rates and the new rate schedule would drive them out of business and would violate equal protection or the due process clause. And the court basically looked at all that. It threw out a bunch of the other constitutional claims that this provider was making on behalf of, unnamed patients and whatnot, but basically said from the provider's perspective, you're under rational basis review. There's a legitimate government interest here in lowering premiums for our insurance, and so it basically just said, provider, you don't have any viable constitutional issues here. And I know we had initially seen a lot of those arguments or concerns being raised when the fee schedule first came into effect, and that part of the decision, kind of been under the radar because of the main decision about the fee schedule. But that other decision has kind of rejected all those arguments, which is a slight silver lining in it, but it is only slight. And that's basically as quickly as I can talk about the two big no-fault cases. I'm not sure if there's any questions on these, but if there are, please let me know in the chat or in the Q&A. Oh,
Okay. Thank you, Grant. I don't see any questions as of now, but maybe we'll get some as they go along and we can address them at the end. But for now, I want to go ahead and introduce our next presenter. That is going to be Tim Diemer. He is a partner at Jacobs & Diemer. He specializes in all forms of appellate practice. He is a past president of the MDTC, so we're very lucky to have Tim. I know him pretty well, and I know he's very knowledgeable. I'm glad that he agreed to do this, and he's going to be presenting the next couple cases.
Hey, thank you, Jesse, and thank you, Grant, for hosting this seminar and for inviting me. I'm happy to participate. Your disclaimer about all areas of appellate practice were well taken. I'm going to be addressing two workers' compensation decisions from the Michigan Supreme Court. Workers' comp is a specialized and arcane area of the law, so you may be wondering what impact these decisions would have in your practice. If my good looks are not enough to keep your attention, trust me, both of these decisions are major and have major implications across the board. I'll address the substance of the rulings to provide context and background, but the particular holdings of the two cases are not the headline for defense practitioners. Instead, how the court reached its decision and the implications are really the headline here, maybe not the narrow workers' compensation ruling. The first case is Doe versus General Motors. It does not have the same draw of Elsayed or Andary or in these major cases, but Doe versus General Motors is a major sleeper case, in my opinion. I believe it spells the end of C8 dismissals, except in the most extreme circumstances. So Doe versus General Motors was a workplace injury. The plaintiff was injured horrifically by a malfunctioning machine at a General Motors plant. Ordinarily, if a worker is injured on the job, his or her sole and exclusive remedy is within the Workers' Compensation Bureau, and the injured worker cannot sue the employer in tort. There's one exception, and that is when the employer is deemed to have committed an intentional tort. An intentional tort does mean intentional tort. It means a coworker punching another coworker, intentionally hurting him. It's a really, really tough standard. It's not reckless or wanton or gross negligence. It truly means intentional. It's a really tough standard to prove. So if any case would warrant a dismissal on a C8 basis, it's going to be an intentional tort exception to the workers' compensation statute. So again, if you've got the example of coworker punching a coworker intentionally, that's pretty straightforward. But most of the times these cases arise where there's a piece of equipment that malfunctions and hurts the employee. And that's exactly what happened to Mr. Doe. There was a press of some sort at General Motors facility. It had malfunctioned in the past. It had a history of not working properly. And Mr. Doe was the unfortunate recipient of a significant injury when it malfunctioned while he was using it. So to show an intentional tort, Mr. Doe basically has to prove that General Motors knew that the press was going to malfunction and knew that he was going to get injured by it, but let it happen anyway. That's almost impossible to show. And not surprisingly, the trial court dismissed the case on a C8 basis, saying there's no amount of factual discovery that's ever going to prove General Motors knew this press was defective, was going to hurt you. Case was dismissed, went through the appellate system, got up to the Supreme Court of Michigan. And the Supreme Court of Michigan reversed the dismissal and said, no, that as tough as a standard as this might be, Mr. Doe at least gets an opportunity to conduct some discovery and prove his case. He doesn't have to prove it with the allegations of the complaint. As long as he alleges sufficiently an intentional tort, he gets his to do discovery and depositions and whatnot. The court had been signaling this change for some time. There have been a number of opinions that come out and have clearly tried to demark the differences between C8 and C10 motions. They're different. They serve different purposes. Legal sufficiency versus factual sufficiency. And the Supreme Court confirmed once again, it's an error of law to blend the two and remanded the case back to the trial court. The plaintiff's attorney was open and honest, arguing the case. He admitted this is a tough standard. He might not ultimately prevail, but he at least deserves a chance to try to prove his case and at least has a chance to produce enough evidence to get this case in front of a jury. So as a defense practitioner, if you're going to file a C8 motion, you better keep it as a C8 motion and say no factual development could ever prove this cause of action because it's not recognized under Michigan law or some other basis. But also for a defense practitioner, this is a theme in this decision and others, is that the Supreme Court is interested in access to the courtroom and to have the parties' fault and liabilities allocated by a jury as opposed to a judge. And there are a number of issues. They're maybe not as obvious and as plentiful as the plaintiff's views, but there are issues where the defendant does not get a full and fair allocation of comparative fault or damages because of a statute or an unfavorable jury instruction. So based on Doe versus General Motors and the next case I'm going to address, if you have those issues in your practice that you think ought to be changed, ought to be reformed, you should be preserving and pursuing these remedies in the appellate courts, because the Supreme Court is signaling to everybody that it is interested in allowing juries to make decisions, not judges. So if you don't like a certain issue being decided by a judge, you want the jury to address it, I can think of comparative fault issues off the top of my head. That would be one issue to present. I see a comment here. And the comment says to ask questions. Okay. No questions on Doe versus General Motors. I'm going to move to the next case. The next case is Cramer versus Transitional Health Services. So while Doe versus General Motors peripherally involves workers' compensation, this one truly is a workers' comp case because it arose out of the Workers' Compensation Bureau. This case, Cramer addressed the standards for a workplace injury and whether a new injury is compensable because it aggravated a pre-existing injury. We have these issues all the time in general civil practice. It also comes up in the workers' compensation system. A worker has some sort of pre-existing injury, workplace injury occurs, and it is aggravated. And in Cramer, the court was called upon to decide what the legal standard should be for aggravation of a pre-existing injury. I don't think that the particular ruling is going to carry over to your general civil practice. But again, the significance to me from Cramer is that the Supreme Court overruled an administrative ruling of the Workers' Compensation Bureau that was issued in 2001 and had guided workers' compensation cases for more than 2 decades. Before I became a lawyer, this workers' compensation administrative decision had been issued. And the Supreme Court looked at the 2001 decision and said, you know what, it does not comply with the statute. The statute says that the new injury must be a significant factor of the injury, and the Workers' Compensation Bureau was treating as the significant factor, which is a much more stringent standard. So the court overruled an administrative decision, which is rare. Courts typically are going to defer to administrative agency and defer to its rulings and interpretation of the statutes that govern it, but not in this case. And not only did the court go that far in overruling an administrative agency, but the court's rationale in the opinion itself stated that the test that had been applied by the workers' compensation too often resulted in rulings against the plaintiff. So it was a result, not result-oriented in the negative connotation of the opinion, but the court looked at it and said, on balance, the injured workers are missing out on their compensation far too often, and we're going to change it. We're going to fix it. So again, even if you don't do workers' compensation, it's not part of your practice. This case is clear as day, if Drew's discussion of Elsayed wasn't enough, that the current Supreme Court is not afraid to overrule longstanding precedent. This case has been on the books for a long time. It was a workers' compensation administrative decision, and the Supreme Court was not afraid to overrule it. And kind of as I discussed earlier, I think over the last 20 years, it's safe to say that the plaintiff's bar probably has more case law precedent it does not like, and has more decisions on the chopping block than the defense bar. But while they may have more, that does not mean that there are not a lot of precedents out there that are unfair or unfavorable to civil defendants. And if the court is willing to, again, overrule an administrative decision from 2001, it's willing to overrule anything that's out there, if overruling Lugo was not enough. So I think this case should be the green light to preserve challenges to legal issues you don't like, your clients don't like, your insurance carriers don't like. Preserve them and seek a good faith change in the law and the appellate system. There are a number of issues that appellate lawyers have been fighting for a long time that have not been adjudicated by the Supreme Court. Get those up there now. I think Andary, following up on Grant's comment, opens up a whole new world of how to challenge some of the more egregiously unfair rules that exist in the no-fault system, which I don't think anyone can say is a defense favorable system the way it's been litigated for a number of years. So Andary completely changed the calculus of the no-fault system, and there are a lot of loose ends and openings there to challenge some of the unfair no-fault rules that exist. I do not see any questions on my workers' compensation presentation. Is that so? I'm going to turn it over to Karen Beach, who's going to address the next case. Thanks, everybody.
Good afternoon. Oh, you're going to say something, Jesse?
I was going to say something, Karen. I wanted to introduce you. This is one of my funnest ones. So Karen Beach is a partner of mine. She's actually just in the next office over. I'm hopefully we're not getting any echo feedback here. She is a principal at Tenuri Knotts, McKinney and Dwayhe. She has been specializing in appellate practice, I believe, since she's been practicing. For whatever it's worth, I can personally attest to her expertise in appellate issues. So very lucky to have her to present. So without further ado, Karen, go ahead.
Thanks, Jesse. Thanks for that glowing endorsement and for the opportunity to talk today. I am going to discuss a medical malpractice case from last term, Kostadinovski versus Harrington. So you can skip past the title slide there. For those of you who don't practice medical malpractice law, a little bit of a background on the notice of intent issue that was raised in this case. Michigan medical malpractice plaintiffs are required to serve healthcare defendants with what is called a notice of intent to file suit. And they have to serve that with 182 days before they file their complaint. And this notice of intent must describe in relevant detail the applicable standard of care, the manner in which the standard of care was breached, how the breach was the proximate cause of the injury, and what the doctor or the healthcare provider should have done to comply with the standard of care. Now, the courts have stated that the purpose of this notice of intent is to give the parties an opportunity to resolve the litigation before the suit is filed. So that is the intent of the notice of intent, is to put the defendant on notice that a claim exists and is going to be filed, and give them the opportunity to work things out with the plaintiff before the ball gets rolling on litigation, people start spending money, etc. The statute at issue is MCL 629-12B, and it provides that each defendant is entitled to a notice of intent addressing the claims against that defendant. And if there's any new defendants that are added during the lawsuit, those new defendants must also then be served with their own notice of intent. Next slide. So what happens in a case when the notice of intent states certain theories of liability against the defendant, but then the plaintiff decides to change their theories of liability after discovery has revealed that maybe those theories aren't reliable? That was the issue in Kostadinovski. It explored what is required of a plaintiff who seeks to change his theory of liability against an existing defendant who was previously served with a notice of intent alleging different claims. The notice of intent in Kostadinovski alleged that Dr. Harrington was negligent in 6 specific ways during this repair surgery, and that this 6 different examples of negligence caused the plaintiff, Drago Kostadinovski, to suffer a stroke. Now remember, his first name is Drago, because that will be important for the end of the slides. During discovery, plaintiff's experts were deposed, and they failed to support any of the 6 theories of liability stated in the notice of intent and the complaint. So they were asked, they went through the notice of intent theories, they were asked about them. They either said, no, this wasn't a breach of the standard of care, or no, this didn't cause any injury to the plaintiff. So plaintiff is coming out of discovery and he's holding an empty bag. But what he finds out from an expert deposition is that did or should have realized this at the time the complaint was filed. But all of a sudden, he's got a new allegation that says the plaintiff was in a hypotensive state during the surgery and was not adequately transfused. So plaintiff comes to court with a motion to amend the complaint to state this new theory of liability, one that he does have expert support for. Now, the Court of Appeals and the trial court did a ton of statutory analysis, because this case went up and down through the appellate court system at least 2 times, maybe 3 times. And so they looked at whether the amendment would be futile, and they looked at whether the amendment of the NOI would violate the notice of intent statute's requirement of the written NOI to be served before the lawsuit is filed, because it's supposed to inform defendants of the theories they'll be defending against. Next slide. So the Supreme Court kind of set all of that statutory analysis to the side. And they said, well, we're going to look at the plain language of the NOI statute. And all the NOI statute says is that the defendant is entitled to receive an NOI before the complaint is filed. And basically, it doesn't matter what that NOI says. It doesn't matter what the allegations are, the theories of liability. As long as they get that piece of paper and they're on notice that a lawsuit's going to get filed, that satisfies the notice of intent statute. So if you want to change theories mid-litigation, you don't have to issue a new NOI. You don't have to amend your NOI. If it's an existing defendant who got an NOI at the beginning of the case, you're good to go. It doesn't matter what theories were raised in the NOI and what theories you want to litigate now under your amended complaint. So the other part of the rule they looked at was the fact that if you add a new defendant mid-litigation, you have to give them an NOI. And they said there's nothing else in the rule that talks about doing a new NOI in the middle of the litigation. So therefore, because the legislature only wanted a new NOI for new defendants, you don't ever have to worry about a new NOI for your existing defendants. Justice Zara penned a dissent that pointed out, I think quite properly, the purpose of the statute is to meaningfully have the defendant and plaintiff be able to meaningfully decide whether to resolve a claim in advance of litigation. So how is the defendant now supposed to meaningfully make this decision when they don't even know what claims they might be asked to resolve later on in the case that aren't stated in the notice of intent? Next slide. So the main holding of Kostadinovski boils down to plaintiffs can now serve maybe what we call a placeholder NOI that states theories of liability that they don't have to end up proving or even pursuing in the litigation. There was a case called Bush versus Shabahang from 2009 that had talked about where the standard was for amending an NOI to state new allegations, and it said that you could amend an NOI if the defendant wasn't prejudiced and if the plaintiff had made a good faith attempt to comply with the requirements of the NOI statute when it was filed. This Kostadinovski case pretty much overrules that. They don't look at whether the plaintiff made a good faith attempt to comply with the NOI statute. They just look to see whether one was filed and whether it meets the statutory requirements. Now, what the defense counsel can still do, and what probably might be the outcome ultimately when this goes back down to the trial court in Kostadinovski, is the trial court can still deny a motion to amend the complaint under MCR 2.118 to state a new theory of liability on the basis of futility, undue delay, undue prejudice, etc. So you've still got the opportunity when the plaintiff brings that motion to amend to say under 2.118, all the defenses that apply, the futility, we're 3 years into this litigation, we've got trial in 3 months, this is unduly delayed, unfair prejudice, all of that. So there's still ways to combat the unfairness of this. It's just, we can't say, well, it wasn't in the NOI, so it can't be added to the complaint and you can't talk about it to the jury. And the Kostadinovski did remand to the trial court to reconsider the plaintiff's motion to amend under 2.118. Last slide. So I didn't want to be outdone by Drew in his memes. And if you'll remember, the plaintiff's name was Drago, Kostadinovski. So here we have the villain, Drago, with his allegations not raised in the NOI, delivering the knockout punch to our hero, Rocky, who represents the doctors and defense counsel years into the litigation. So this may knock us down, but it will not keep us down in defending our clients. Thanks.
Oh my gosh, that was amazing. She had to explain that joke to me earlier. I didn't get it. So thankfully.
So you're not a child of the 80s.
I am not. I'm doing my best. I should have recognized it. Anyway, okay. I have the privilege of oh wait, we got some chats. Hold on. Okay, here we go. Let's see, here we go. Following up on Mr. Diemer's theme that no precedent is safe, Supreme Court has also shown interest in overruling Waltz v. Wise regarding the notice of intent tolling in medical malpractice cases implicating the wrongful death savings period. So that is true, and that's a very good point. So Waltz v. Wise was a case, and thank you very much for that comment. Waltz v. Wise was a case that essentially held that the NOI tolling statute, so when you serve an NOI, you have to wait 182 days. And there's a statute that says that the statute of limitations is tolled during that 182 days. If the statute of limitations was scheduled to expire during that period. But the Waltz v. Wise case essentially said that because the statute only refers to statutes of limitations and repose, it doesn't toll savings periods, such as the death savings period, which is an alternative to complying with a notice of intent and allows you to file a claim during a specified period after death. And it looks like what Kevin McQuillan has pointed out is they are signaling an intent to perhaps change that decision as well. And I think it sort of goes with what Tim was mentioning, is that the Supreme Court, at least in these opinions, is not shying away from overturning precedent. And like Tim said, I think that we can perhaps use that and try to get the court to revisit some some unfavorable cases to the defense. So, and Kevin now says that it looks like there are at least 3 votes in favor of overturning Wise. So that could be on the chopping block next. It remains to be seen when and how that'll happen. Okay, I'm going to skip my introduction. I have the pleasure of discussing another medical malpractice case, Ottgen versus Katranji. So in order to, this is a case that involves not a notice of intent, but an affidavit of merit and its implication on the running of the statute of limitations. So I wanted to briefly just give a little primer about medical malpractice cases and the affidavit of merit. Like a notice of intent in a medical malpractice case, a plaintiff has to file with the complaint, and that'll be important later, that's straight from the statute, a affidavit of merit filed by a health professional who the plaintiff or their counsel reasonably believes is qualified under the statute to testify as to the standard of care for the defendant doctor. The statute says you have to file it with the complaint. There's also exceptions to that with the complaint requirement. You can move for an extension of 28 days to file an affidavit of merit if you show good cause after filing the complaint. And there's also another subsection that says you can get 91 days if the defendant doesn't allow access to medical records as required in the notice of intent statute. Now, case law has said that the purpose of an affidavit of merit is to deter frivolous lawsuits. So the idea being that if you already have to get, by the time, in order to even file a complaint, you have to have an expert that is willing and opining that there was a breach in the standard of care, that it did cause injury and there are damages. And again, similar to the notice of intent statute, an affidavit of merit is required for each individual defendant. Well, in 2000, the Supreme Court issued an opinion, Scarsella versus Pollak. And this is the decision that this case, Ottgen, overruled. And what the Supreme Court held in this case is that because an affidavit of merit is a requirement for a medical malpractice action, and because the statute says you have to file it along with the complaint, essentially a claim for medical malpractice cannot be commenced without that affidavit. And then it looked to the statutes regarding the statute of limitations for medical malpractice actions and essentially said that because of this requirement, the statute of limitations is not told if you file a complaint and there's no affidavit of merit. Now, the Supreme Court did acknowledge in that case that the statutes regarding commencement of an action do not explicitly say anything beyond filing a complaint. But what it held is that holding otherwise and allowing a complaint to be filed without an affidavit of merit would essentially frustrate the entire purpose of the affidavit of merit statute. Because of that requirement, only in med mal cases, if you don't file an affidavit of merit, the statute of limitations is not told and the action is not actually commenced. So there were a few subsequent decisions that relied on Scarsella that are important to discuss. Kirkcaldy v. Rim is one of them. So after Scarsella, there were a couple decisions, and I don't think I have them written down, I'm blanking on their names, but they took Scarsella and sort of expanded it to defective affidavits of merit, essentially saying that even if you file a defective affidavit of merit, meaning one that does not comply with the requirements of the statute, then that also means that the action was not commenced and the statute of limitations did not run. Well, Kirkcaldy overruled those two Court of Appeals decisions, saying that only when you omit filing an affidavit altogether is the statute of limitations not told and the action not commenced. Even if you file a defective affidavit of merit, it still tolls the statute of limitations. And then in 2011, Supreme Court issued Ligons, which essentially wrapped a lot of these cases up and explained the different aspects of it. It clarified that from Kirkcaldy and Scarsella, if you omit an affidavit of merit, it doesn't toll. If you have a defective affidavit of merit, it does toll. But once the trial court determines that the affidavit is defective, it still results in dismissal. The only difference being now after dismissal, the statute of limitations then continues to run and you would have whatever time remains in that statute of limitations to file your action. And an important, well, not super important, but a little quirk of Ligons is that the court also had that an affidavit of merit cannot be amended because it's not essentially a pleading. But it did acknowledge that in May 2010, the amendment to the court rules 2.112 and 2.118 became effective, essentially allowing the amendment of an affidavit of merit. The only issue in Ligons was the effective date of that that court rule was after the commencement of the action, so they did not apply it. So essentially, going forward, any cases from May 2010 onward, you could amend an affidavit of merit. So in 2017, Justice Viviano, who authored the opinion in this case, started signaling his dissatisfaction with the holding in Scarsella. And plaintiffs' medical malpractice attorneys have been banging that door down for a while. They really did not like the holding in Scarsella, because essentially when you're up against the statute of limitations, if you don't get an affidavit of merit and you don't move for an extension, and then later the case gets dismissed, it's dismissed with prejudice because the statute of limitations had already expired. So in Castro v. Goulet, Justice Viviano authored a dissenting opinion from the order denying leave, basically saying that we should go back and revisit Scarsella. I think that he said that it needs to be reconsidered. And then in a subsequent case the year later, he again stated that he has questions or reservations about whether Scarsella was correctly decided. And then eventually in this case, Justice Viviano's reasoning prevails. The court essentially held in what is basically a unanimous decision. There was only one concurring opinion from Justice Zara, that Scarsella was wrong, that even if you've just filed a complaint without an affidavit of merit, it still tolls the statute of limitations. And essentially what Justice Viviano held is that it disagreed with the holding of Scarsella that the purpose of the affidavit of merit statute would be frustrated. He looked to the language about commencing an action in other statutes, saying it doesn't say anything about an affidavit of merit. Essentially, these statutes only require a complaint to be filed to commence an action and for a statute of limitations to be told. And there was no reason to add the requirement specific to med mal actions that the affidavit of merit is required to commence an action. He also clarified, and this is kind of an important point going forward, is that dismissal does not have to be without prejudice just because the statute of limitations hasn't expired. The court still retains discretion to dismiss an action with prejudice if warranted under the facts of that case. And Justice Zara's concurrence sort of emphasizes that fact using the facts of Scarsella. So going back, Scarsella involved a unique situation where there was no affidavit of merit filed. The complaint was filed, I think, about 2 weeks before the statute of limitations was going to expire. Defendant then moved for summary disposition because of the lack of affidavit of merit, and it was 213 days after the complaint was filed and 2 days before the hearing on the motion that the plaintiff finally filed an affidavit of merit. So it was obvious that that affidavit of merit was not available at the time the complaint was filed, and it had been obtained only after the motion was filed. So what Justice Zara concluded is that Scarsella reached the correct decision just on the wrong basis, saying that in that case, the trial court still was correct to dismiss it with prejudice because it was obvious that the complaint was filed and that the affidavit of merit statute was basically intentionally not complied with in order simply to try to get the statute of limitations to toll. So that sort of brings us to, what do we do now? Well, we can no longer file motions and for dismissal with prejudice based on the failure to file an affidavit of merit. The case would likely still be entitled to dismissal. It would simply be without prejudice, and then the plaintiff would then have whatever time is left on the statute of limitations to file an action. But Justice Zara's concurrence sort of gives us a little bit of a blueprint to what we can do. We can look at, when was the statute of limitations set to expire? So, for instance, if the statute of limitations was set to expire maybe 2 days after the complaint was filed, complaint gets filed, there's no affidavit of merit, no motion to extend the time period, and then after defense files a motion for summary disposition, maybe then the plaintiff files an affidavit of merit in response to that motion. Well, I think it can be persuasively argued that the complaint was filed and the affidavit of merit required was intentionally not complied with simply to obtain tolling. And under those circumstances, the plaintiff should not be rewarded for intentionally violating a statute, and that therefore dismissal should be with prejudice. And I think that is sort of the arguments we're going to have to make going forward to try to obtain dismissals with prejudice, rather than allowing the plaintiffs to simply obtain tolling by filing a complaint, knowing fully well that they have not yet obtained an affidavit of merit. So I think that's sort of all we're left with. It's a big tool. I know I do a lot of med mal work, so it was very often to file these motions and get dismissal with prejudice, and that's just simply not going to be a default remedy. We're going to have to find other ways to try to obtain dismissal with prejudice. Okay, I don't see any questions in this case for now, so I'm going to move on to next case, Woodman versus Department of Corrections. So we're switching gears a little bit. This is not a med mal case. This was a FOIA case, and the case involved the attorney fee shifting provisions in FOIA and whether or not a party has prevailed in full or in part. So background of the facts of Woodman. Two journalists filed FOIA requests to the Michigan Department of Corrections seeking some videos and audio recordings of an altercation that led to a inmate's death. The MDOC denied the FOIA requests, and then the plaintiffs filed suit seeking enforcement of the FOIA request. Court of Claims granted the plaintiff's motion for summary disposition and ordered the Michigan or the MDOC to produce the videos. And it was a little bit confusing about the facts, and that is going to be important later, whether or not the unredacted videos were in fact ordered. It appeared that there was no, that the orders from the case did in fact order production of the videos unredacted. However, after the resolution of that, the plaintiffs requested the ability to be able to redact and blur the faces of the individuals in the video. And from the majority opinion, it seems that the plaintiffs simply did not oppose that request, and therefore they disclosed redacted versions of the videos. Then after the disclosure, the plaintiffs moved for attorney fees and costs pursuant to the fee shifting statute in FOIA. The plaintiffs were represented by the ACLU and also Honigman. So the defense argued that they did not prevail, that the plaintiffs did not prevail in full because the defendants were allowed to redact the videos, essentially saying that they requested unredacted videos, and because we were allowed to redact it, they didn't prevail in full, and the fee shifting, the attorney's fee should be discretionary rather than mandatory. Court of Claims disagreed. They said that they prevailed in full, but what was unique that the Court of Claims did is they reduced the amount of fees awarded to Honigman only. ACLU got 100% of their fees, but they reduced the fees for Honigman because Honigman took the case pro bono. And that was the only justification the trial court used for reducing it from 100% down to 10%. So case went up to the Supreme Court, and there were two issues: whether the plaintiffs in fact prevailed in full because of the redactions, and whether the Court of Claims abused its discretion in reducing Honigman's fees simply based on the pro bono aspect of the representation. The majority found that the plaintiffs did in fact prevail in full, and it was a very specific reason why. They looked at the FOIA request, pre-litigation FOIA request, and determined that they did not actually request full unredacted versions of the videos. To prevail, it cited case law saying one of the elements of prevailing in full is that the plaintiffs must have, quote, obtained everything it initially sought. The majority relied on that FOIA request in finding that they didn't request unredacted videos. They simply redacted the videos with the audio accompanying it, and therefore they obtained everything they wanted. Even though the complaint that was filed requested unredacted videos. So essentially it was looking to the FOIA request and not the complaint. Well, the dissent simply reversed it. They said that there did not prevail in full because they looked to the complaint to say that obviously they were filed suit seeking unredacted videos, and because the videos were in fact redacted, the plaintiffs did not receive everything that they obtain everything it initially sought. And there was a bit of a factual dispute that I could see regarding whether the plaintiffs actually opposed the redactions. The majority relied on the fact that they didn't oppose the redactions, and the redactions request occurred after the defendants had already been obligated to produce the videos. Whereas the dissent said that the plaintiffs did in fact oppose the redactions. So I thought that was sort of unique, where there's a factual dispute between the majority and the dissent, and it was directly relevant to the decisions they reached. As to the reduction of Honigman's fees, the majority determined not only that the trial court abused its discretion in reducing fees based on the pro bono nature of it, they held that you can't consider whether or not representation was pro bono in resolving the fees. And they did it primarily, it seemed like a public policy argument. They said that we want to promote pro bono representation. It doesn't affect the reasonableness of the fee request, and it would be essentially bad policy to allow trial courts to reduce fees just because it's a pro bono representation. The dissent, Justice Adora and Viviano joined, said that, well, we're not saying that you need to reduce it or that you have to consider it, but essentially said it's a relevant consideration that the trial court should be allowed to consider. So it really seems like more of a policy issue. I did also want to note that there's Smith-Purgu factors. There's a non-exhaustive list of factors that trial courts are allowed to consider. I think they had 8 factors listed and it was not exhaustive, but pro bono representation wasn't included. And essentially that was the difference between the majority and the dissent. So I thought it was a unique case, maybe not unique, but a worthwhile case in that it signaled the court's willingness to at least consider, again, public interest factors and policy arguments for decisions, why they're going to reach decisions. I think that I might, if you're asking my opinion, I don't know why pro bono needs to be specifically excluded other than that public policy argument. So it seems to me that that was really important for the majority's decision in categorically restricting trial courts from considering that in evaluating whether or not fees are reasonable. And that was essentially the holding of that case. And I do not see any questions. So unless I get one in the next couple seconds, we're going to turn it on over to Tom Ludden, our next presenter.
Good
sorry,
afternoon.
Tom. I owe you an introduction. I'm sorry, I forgot.
Okay,
Tom Ludden. He is a partner at Lipson Nielsen. He specializes in appellate practice and commercial litigation. And one thing, Tom and I are both on the committee, the Michigan Appellate Bench Bar Conference Planning Committee. It's coming up in 2025. So if you're interested, please look out for communications on that. It's a great conference. It's one of my favorite conferences. Only every 3 years. This is, I think, my favorite thing that we do, and it's extremely valuable for appellate practice. So with that, I'll turn it over to Tom.
Yes, and since I do a fair bit of legal mal-defense, or have historically, we tend to shy away from the word specialist and a different standard of care. But so we have 2 cases here. Anyway, stepping back, there were 26. Do you have my PowerPoint or no? Did that not get done? Oh, there we go. Okay. So there were, in the last term, 26 formal opinions from the Michigan Supreme Court. And you can roughly characterize them as 10 being criminal, 4 having to do with ordinances or taxation, 1 family law, and 1 judicial tenure commission matter, with 10 civil cases being decided. And then if we go to the next slide, we will see that 1 of those 10 cases was a UCC case, which turned out to be timely for me because it came out about 10 days before I sat for the Nevada bar exam. So it was helped me to prepare for that. There were 9 tort or tort-related cases that we've talked about today, most of them. And the 2 cases I'm talking about are 2 sovereign immunity cases, Christie and Elia. So let's go to the next slide. Both of these cases deal with sovereign immunity, which has always seemed to be an odd concept that we have in American jurisprudence. It's a holdover from something we inherited from our British cousins, who historically had a monarchy that was very restrictive and very protective of its rights. When Henry VIII prosecuted Anne Boleyn for treason, she could not hire an attorney, cross-examine witnesses, or do anything to defend herself against the claim of treason. So if you're not allowed to defend yourself on a claim of treason, it would logically follow that you couldn't sue the king if he breached a contract to you. Eventually, we have caught up to the idea that this is not the right way to proceed, but it wasn't until 1939 that Michigan enacted a statute, the Court of Claims Act. That was the first legislative scheme that authorized suit generally against the state of Michigan and its various agencies and officers. Over time, the Michigan legislature has vested exclusive jurisdiction for most claims in the Court of Claims. There's a few exceptions to this. One is for claims where a party has a right to a jury, and that may be filed in an appropriate trial court. And then important for one of the two cases here is that under the Elliott-Larsen Civil Rights Act or the Persons with Disabilities Act, both of these statutes expressly provide that claims against the state may be filed in a circuit court, not in the Court of Claims. So there are a number of procedures if you want to file a claim against the state of Michigan under the Court of Claims Act. And this is our key provision for the cases that exist here. And I'll paraphrase that, except as otherwise provided in the section, a claimant cannot sue the state of Michigan unless within 1 year after the claim has accrued, the claimant files either a written claim or a written notice of intent to file a claim with the Court of Claims. And then in subsequent sections, the next following section, which I don't have a slide for, is the one that provides the contents of the notice that must be provided. And it is very similar to the requirements that a plaintiff must contain in a notice of intent before filing a med-mal claim. So let's move on to the next slide. The critical question in these two cases, Christie and Elia, is whether the notice procedure that's contained in the Court of Claims Act also applies if the lawsuit is not filed in the Court of Claims. And there are, as we say, a number of claims that don't need to be filed there. So let's move on to the first case we'll discuss, which is Christie versus Wayne State. Wayne State fired the plaintiff in November of 2017. She filed a complaint as permitted and authorized in the Wayne Circuit Court, claiming that she had been fired because of age discrimination. And she filed that claim about 18 months after being terminated. She had not filed a notice in the Court of Claims of her intent to sue. The defendant moved to dismiss, saying that the Court of Claims Act requirement applied. Wayne Circuit Court denied the motion. The Court of Appeals heard it on an interlocutory review, and it affirmed the denial on the basis of a case called Tyrrell versus the University of Michigan, which is a 2020 case. And Christie was decided a few weeks after that. The Supreme Court granted leave to decide whether or not Tyrrell was correctly decided. Tyrrell had decided that you don't need to follow the Court of Claims procedure if you were filing a claim that could be permitted in a circuit court claim. The Supreme Court reviewed the statute. This is a case of statutory analysis. And it concluded in an opinion written by Justice Zara, a unanimous opinion, that except as otherwise provided in the section, a claim may not be maintained really means that it was mandatory to all claims not covered by the except clause. And there is one type of claim that is covered by the except clause, and that is workers' compensation claims, and that's in subsection 5 of the provision establishing the claim procedure. So the Supreme Court in this case has a win for the defense because it overruled the Court of Appeals and the Wayne Circuit Court and found that this claim must be dismissed because the plaintiff did not follow the procedures and file a written notice of intent to sue in the Court of Claims within 1 year of her claim accruing. So our next case, which was argued the same day and decided the same day, is Elia Companies versus University of Michigan Regents. Is a slightly different set of facts. The plaintiff was a tenant at the Michigan Union. There was a dispute that led to Michigan terminating its lease and ordering plaintiff to vacate the premises. Plaintiff filed suit in the Washtenaw Circuit Court about 6 months later, and the defendant filed a notice of transfer to the Court of Claims, because this is one of the types of claims where there is express jurisdiction within the Court of Claims. So the Court of Claims dismissed the case for failure to comply with the notice and verification requirements of the Court of Claims Act. Court of Appeals affirmed the dismissal of the tort claims, but reversed the dismissal of the breach of contract claim, finding that the plaintiff could comply with the verification requirements by filing an amended complaint that was verified, even though that amended verified complaint was prepared and filed more than 1 year after the cause of action accrued. So the question is a little bit different in the Supreme Court. If we can move to the next slide. Supreme Court first found that the statutory requirements do apply, even though the case was filed in the circuit court. So our issue becomes whether the plaintiff can file an amended complaint to correct the defects that were in the original complaint, and the defect being that it was not verified. The Supreme Court says, well, yes, it can. However, it needs to be timely filed within 1 year of the claim arising, as required by 600.6431(1). This amendment was more than 1 year afterwards, so the case is dismissed. So these are two cases here where we actually have wins for the defense, which is fairly unusual. I did note that there was a third statute of limitations case, which was also a partial victory for the defense on sovereign immunity grounds again. So what do we take away from all this? Because we have here cases dealing with notices that are required, where in the Med-Mal area, the cases were not dismissed, whereas in the sovereign immunity cases, the cases were dismissed. And I think at least one difference here is that the requirements that were not met in these two sovereign immunity cases are ones that need to be met before suit is filed or before the 1 year period expires. They're not dealing with a situation that arises while the case is pending. So I think still, if you do not file or do not serve a notice of intent in Med-Mal, you cannot move forward and file a Med-Mal case, or if you do, it's properly dismissed without prejudice. I think, and this is a point that is made by Justice Zara in his dissent or his partial concurrence, I'm not sure what you'd call it, in the case that I have extreme difficulty pronouncing, Kostadinovski It's really hard to write a statute that covers every eventuality, because you have what this legislator is trying to do is give notice of intent of what the claim is to medical professionals, and that clearly doesn't happen in the MedMal case that was decided this term, but yet the suit is allowed to proceed. Here you have suits that are not permitted to proceed. I think we have a great trend over the last 40, 50, 60 years towards replacing the common law with statutes. It's hard to do. And it's hard to figure out what problems may arise in the future and to deal with that. I think a final point is that words do really matter. If the notice of intent statute were written slightly differently and perhaps said that you cannot pursue a claim as opposed to an action unless you describe the claim in the notice of intent, perhaps you get a different result. So that is perhaps one takeaway that we have here. Anyway, next slide, please. I think we have a few future questions in the sovereign immunity area. What happens if a plaintiff files a notice of claim with the Court of Claims and then files a complaint that has a different claim? It'll be interesting to see if that arises and what happens. Or what happens if the plaintiff files a notice of claim, files a lawsuit making the same claim, but then moves to amend to assert a completely new claim, or one that even contradicts the prior claim. We do not know how that will work out. Couple more future questions that may exist. Next slide, please. These are all cases, both the MedMal cases and these two sovereign immunity cases, dealing with statutory interpretation and the text of statutes. So are there any statutory amendments that could be enacted as a result? I mean, one possibility is you could get more exceptions from the requirements of MCL 600.6431.1. So in addition to workers' comp claims, perhaps there will be other claims that could be filed without filing the notice. There are possible statutes that, I do not believe would have stand any chance under the current legislature or governor, but that defense attorneys may consider, or defense-oriented persons dealing with the timeliness of amendments to correct defects in notices or complaints, perhaps amendments of 600.2912B to establish consequences for failure to comply, or trying to pursue a claim that is not disclosed by a notice of intent. We had a great deal of legislation during the 1990s that changed things a great deal in the state of Michigan. That is 30 years ago. So, and some future legislature under some future governor, there may be a possibility of cleaning up and amending and enacting the intent that many people think were behind a lot of the tort reform in the mid-90s. So if you have any questions, I think we're unfortunately about out of time here, although I have time to stay.
Okay, thank you so much, Tom. I do not see any additional questions in the chat. So I don't know if we have to stay too much longer, but just buttoning it up, I think that in my opinion, we have two takeaways, at least, that I can identify from this round of opinions. Is that first, this court is not, and as Tim mentioned, this court is not going to shy away from overturning decades-long precedent that it disagrees with. It doesn't look like stare decisis is much of a barrier for the courts. It seems like it's a hurdle that's becoming increasingly easy to clear. And the second being that, what was the second one? Well, maybe that's the big one. I don't know if anybody else has, any of the other panelists wanted to bring any. It was that going forward, we're going to have to be prepared and as Tim mentioned, to anticipate future challenges to more of these decisions. It seems to me that the favorable defense decisions that came out in the early 2000s are all subject to being reconsidered now that it's been about 20 years since these opinions were decided. So it's something that we're going to have to anticipate, and we're going to have to defend if we want to preserve the status quo, or at least be willing and able to adapt and find new ways to defend our clients against what may be a more difficult environment going forward. So unless any of the other panelists had anything else to discuss, I want to thank everybody for joining us today. I want to thank all of our panel members on behalf of Grant and myself for joining us and explaining these cases. And I also wanted to mention one more time the upcoming events that we have coming up for the MDGC. We have the winter meeting on November 3rd and the Legal Excellence Awards next year on March 21st. So if you're interested, please register and join us. And looks like with that, we will conclude our webinar today.
Thank you, Jesse. Thank you, Grant.
Yes, thank you guys.